case number 30005, State of Ohio versus Hedy Moss.
Hedy
Moss. Okay, thank you. The panel, as you can see, is Judge Hensel, Judge Callahan, and myself. I'll be presiding and keeping track of the time. Each party will have up to 15 minutes to present their argument. Attorney Kelly, if you're going to reserve time, let me know. For rebuttal, let me know, and I'll keep you appraised as to how close you're getting to that rebuttal time. The arguments are recorded, as you both know, so if there's reference to children or victims, please do not use names. We just use initials or otherwise refer to them. I think that's all I have before we get started, other than to say, of course, Judge Hensel, Judge Callahan, and I have read the briefs, and we are prepared to proceed when you are. So let me ask, just to start off, Angie, do you want to reserve some time?
I would, Your Honor. Can I reserve 5 minutes?
5 minutes, very good. All right, I'll let you know when you get about 10 minutes into your argument then.
Perfect, thanks.
Okay, you may proceed.
Thank you, Your Honor. May it please the court, Attorney Angie Kelly on behalf of the appellant, Hedy Moss. The issue for the court's consideration today, at least the first one I'd like to discuss, is that the trial court erred by not granting the defense motion for a mistrial based on prosecutorial misconduct. The basis for that primarily being the prosecutor making inappropriate, improper reference to the previous trial. As the court is aware, Ms. Moss did have a full jury trial in front of another judge about 1.5 years prior to this. There was some extensive discussions in the records. There would be no references made to that during the trial. The prosecutor, particularly in 2 places, and I find the one during cross-examination to be the most egregious, basically was trying to impeach her based on her testimony from the previous proceeding with what he asked her. And to me, although the court found that there was no actual prejudice, and it is our position that Ms. Moss was prejudiced by these 2 things that were brought up by the prosecutor during the course of the trial, because it made it very clear that there was a very serious prior proceeding in this situation, and that during that prior proceeding, that whatever took place was being hidden or otherwise, not being allowed to be considered by the jury. I think that places way too many questions into the mind of those jurors as to what took place, how it played out, what's being hidden from them, what previous decisions had been made by the court in order for them to go into their deliberations without any preconceived notions or ideas in the back of their mind. As a result of that, I would say that clearly the actions were improper, as the court had instructed them not to do that, and that they were not harmless by any stretch of the imagination, and that the court should have granted that motion and given them the opportunity for a new trial in this instance. Second one.
Remind me, did the court instruct them to disregard?
I don't believe that she did on the first one, because I'm sorry, Judge, off the top of my head, I can't recall if Attorney Jones, I know during closing argument that the trial counsel immediately asked for the mistrial, moved to strike, and they went sidebar, and the judge was like, no, but let's not let that happen any more times during the course of this, because it's contrary to my ruling. I do not have any recollection of reading that she told the jurors to disregard or to strike.
And we can check the record on that. So
thanks. I apologize for that, but that one didn't pop into my head. I apologize. Next issue that I certainly wanted to discuss with the court, and it's a little bit abnormal, is that that trial counsel was ineffective during plea negotiations. I know the court is very familiar with the Strickland standard. We all are, as it's been the same for quite some time during the course of case law history. But in this particular instance, Ms. Moss obviously was charged with extremely serious offenses that carry a life sentence, minimum of 15 years to life sentence. And it didn't happen until the morning of the second trial that there was any conversations regarding whether or not a plea offer had been made. At that time, trial counsel did indicate that there had been basically no plea negotiations during the course of that case. And there were there was a new judge and there were new prosecutors on the case. So I don't think you can really assume that it overflowed from the previous one. Situation had changed, especially due to the fact that there was a mistrial no verdict as it relates to the murder charge, the most serious one. So in this instance, there had been nothing up until the very morning of trial, which Ms. Moss had been, due to the COVID-19 pandemic, sitting in prison for the better part of, oh, I'm sorry, that was for sentencing. I apologize. She'd been in jail, though, for a significant amount of time, in addition, waiting for that, in which some of that could have taken place. Morning of trial, she comes into court, the court inquires. At that point in time, the state finally made an offer to resolve the case, which was a substantial reduction to what she was actually charged with. There's a pause in the proceedings, and then there's basically nothing else except for trial counsel coming out and announcing that she wasn't interested and they were proceeding to trial. I can't find any law that specifically indicates that they have to do this, but as a practitioner for the better part of 20 years now, I have never had a case with a serious charge where somebody is offered such a significant reduction that drastically reduces the amount of time that they're being offered, that the court doesn't inquire of that person individually. And in fact, I feel as though the law should mandate that if there isn't something out there already. Because the reality of the situation is, even though we're represented by counsel, especially in a case like this where it comes up so last minute and that individual really hasn't had any opportunity to have extensive discussions. I mean, this record doesn't tell us whether or not they were in there for 5 minutes or an hour or how long she really had to consider it. But under normal circumstances, what we would see is the trial judge saying, this is bringing the defendant into the courtroom. This is what you've been offered. Do you understand what the difference is between this charge and this charge? Have you had enough time to talk to your lawyer about the difference between this charge and this charge to be making a knowing decision as to whether or not she should accept that offer or proceed to trial? Well, we don't have any of that. Well, of course, from an appellate perspective, that makes for a really difficult position because we need a record. We need something that we can look back on and say whether or not the attorneys did anything wrong. Unless this court were to agree with me and find that it should be mandatory for the trial judge to do that, especially in cases like this. But the reality is that we have a pretty absent record. And with that absent record, I searched and searched, and it makes it extremely difficult for an argument to rise to the level of what would be a Strickland standard for ineffective assistance of counsel, because all the case law is basically saying that if that were happening and that there is a lack of a record, that perhaps we need to file a motion for post-conviction relief. Well, that's all fine and dandy with a few major flaws to it. And as we're all aware, there is no right to counsel for post-conviction relief. In addition to that, limited time frames. And if there were to be any type of a hearing as it relates to a post-conviction motion, in order for us to be able to get more information or have the court further analyze the situation, once again, she's not entitled to an attorney. I mean, we're talking about a very serious constitutional right here under the Sixth Amendment, and that's the right to effective counsel. And essentially what I'm seeing is case law that's saying, well, there's another remedy for this, even though you don't get the benefit of counsel to help you with that. And I think that's insufficient. Is it possible that I missed something? Of course it is. But it would be our position that the court should find that in a situation like this, particularly if we're dealing with something as serious as the crime that we are dealing with, that the court find this as a basis to remand so that she can go back to the trial court, have the benefit of counsel, and have all of that information re-relayed. I realize that that is a very drastic thing that I am asking the court to consider doing, but I also think that when it comes to the preservation of somebody's constitutional right to counsel and to a fair trial, that sometimes we need to do the extreme to ensure. This is something that, at least me personally, was unaware. I feel that this is like a flaw in the law that needs to be fixed because these individuals need to have some understanding, and we need to make sure that they know what they're doing when they're making decisions like this. Like going back to the idea of whether she knowingly rejected this plea offer. Obviously I have conversations with my clients, and I'm not foolish enough to think they don't occasionally not tell me the truth. But if we had this all fleshed out in the courtroom, it would have been very clear as to what her intentions were and whether or not she actually understood what was being relayed to her. And we don't have any of that. And I feel like that in and of itself raises enough concern as to not just the effectiveness of her counsel, but the fairness of the overall procedures that could justify a reversal in this instance.
Wouldn't that create a problem if the court got involved in those plea negotiations? Defendant catches wind of how the court may be leaning in the case and then waives a jury based on discussions they had with the court. And you don't have to go into depth on this because you're closing in on your rebuttal time, but just out of curiosity, I'd love to hear your answer to that.
I mean, I would say no. I'm not asking that the trial judge has to get involved. They don't need to offer an opinion. And what I'm saying is that they need to very clearly just lay out or have the state and defense on the record. This is what was offered. This is the charges. This is the change from what you're facing right now. Do you understand them? Have you had enough time? Do you wish to avail yourself to that? Offering an opinion as to how they would proceed otherwise is a little different. And that's not what I'm asking this court to consider.
All right, thank you. You're at 5 minutes and 12 seconds right now. Do you want to reserve or?
I will reserve.
All right, we'll give you 5 minutes then for your rebuttal. All right, 15 minutes for the state.
Thank you. May it please the court, Heaven DiMartino on behalf of the state of Ohio, the appellee, we're asking that this court affirm Ms. Moss's convictions in both trials. With regard to the issue of prosecutorial misconduct, the record shows that at page 841 of the transcript, the prosecutor asked Ms. Moss whether she had talked about her daughter after she fled the scene at the prior proceeding. She called it prior, the prosecutor said prior proceeding. The defendant answered the question. There was no objection. The course of the conversation continues. Then in closing argument, the prosecutor refers again to that statement about the prior proceeding, doesn't say trial, just says prior proceeding. At that point, the defense objects. There's a discussion. The prosecutor basically notes that they were hearkening back to that testimony during the cross-examination. There's no finding that there was anything prejudicial, and the court just asked the prosecutor to not make any more references with regard to prior proceedings. So the lack of the objection during the cross-examination forfeits any error there. With regard to the issue at closing where there was an objection, the law is clear, and appellant correctly laid out the law with regard to what it would take for a finding of prosecutorial misconduct, which would be that basically if the comment was improper, and the state does not believe that it was, but if it was, it would have to rise to the point that without that comment, there still be a finding of guilt. So in this case, the evidence is overwhelming that Hedy Moss committed the felonious assault and caused the death of Ernest Sherman, as well as the felonious assault of Mr. McMillan. She admitted it. The entire point of having a trial was because she says it was self-defense. So the issue would be, would prior proceedings somehow overcome the state's evidence with regard to the fact that Hedy Moss did not act in self-defense? So based on that, there could be no finding that there was prosecutorial misconduct based on this one isolated statement during closing. As far as the offer, Ms. Moss was in court when the state noted and the defense counsel noted that there was an offer for manslaughter. There's no requirement that the court inquire of a defendant as to whether or not they understood that offer. That is a plea negotiation that is relayed between the client and counsel. In this case, manslaughter does not really, it doesn't make sense. Ms. Moss, her opinion was that she acted in self-defense. So if you're going to have a manslaughter plea, that's not going to be consistent with what Ms. Moss was trying to say happened the entire time. She's saying she acted in self-defense. So for her to accept a manslaughter plea, she would have to then be saying either that she acted in the heat of passion or that she was committing another offense and somebody died. right? Those are involuntary manslaughter and manslaughter. And in this case, that was never the position that was portrayed through defense counsel by Miss Moss. She said she went to the house. She testified in both trials. She went to the house to get crack. And in her version of events, Mr. Sherman turned on her and got handsy and physical. And she had no choice but to reach into her pocket and shoot him. And then she thought Mr. McMullen was coming at her too, and she shot him, which is completely inconsistent with the testimony, of course, of Mr. McMullen. So based on that, if you are going to issue a bright line ruling that there has to be some type of inquiry and discussion with the defendant as to whether the defendant understands what would happen if they entered the plea to manslaughter versus murder, it would require potentially that this defendant would have to then incriminate themselves and maybe talk about parts of the case. So we presume that attorneys are competent. We presume that there was a conversation with regard to the plea, and that is what the case law requires. And counsel acknowledges that there is no case law that requires otherwise, and there's nothing in the record to suggest that there was not a discussion with defense counsel and Ms. Moss and that the plea was entered knowingly. To get into things outside of the record obviously is inappropriate on a direct appeal, and we do have other mechanisms, whether they are the mechanisms we prefer or not. That is the way that the law is set up in the state of Ohio. With regard to the two arguments with manifest weight of the evidence, at both trials, the testimony was consistent. Mr. McMullen testified at both trials that he was in the house, that Ms. Moss arrived at around 4 a.m. She wanted to talk to Mr. Sherman. They went and got Mr. Sherman. Then there's three of them in one room. And that without any provocation, without any weapons being present, Ms. Moss shot Mr. Sherman in the head and then shot Mr. McMullen in the arm. He jumped out the window to get away. He makes a comment to Mr. McMullen, says that Moss comments to him, "I should have killed you too." In both trials, she acknowledges she had a gun with her in her pocket. Those statements and the fact that she went there with a gun are consistent with someone whose intention was to cause harm, maybe even death. They're not consistent with self-defense. So in this case, while she did testify and she did present a version of events that, if believed, could support self-defense, clearly the jury was within its purview to disregard the testimony of Ms. Moss and to instead find that the testimony of Mr. McMullen and Aisha and the officers who testified that there was no weapons found in the house, that Ms. Moss had no visible injuries on her, despite her assertions that she was grabbed by the neck, that she could barely breathe. And the fact that she finally does admit that she threw the gun, and then she lied about that, and she also gave false identification. There's overwhelming evidence that this was a crime that was done with the purpose to cause harm, serious physical harm, and death to these individuals. So based on that, we would ask the court to affirm the convictions and find that the verdicts for murder and felonious assault for both victims with regard to felonious assault were supported by the weight of the evidence. There was not prosecutorial misconduct, and the evidence does show that there was a plea offer, that the denial of the plea was done voluntarily and knowingly by Ms. Moss. And based on that, the state would ask that this court affirm the convictions. If there are no questions.
Didn't the self-defense law change between trial 1 and trial 2?
The defense law,
Self-defense.
Right, the self-defense law did change. In both cases, though, the evidence was shown by the state that there was not self-defense. So it was sufficient with regard to the burden shift for both trials. And the testimony was almost verbatim. There was very little change with regard to what was introduced at trial 1 and trial 2. If there are no other questions, I'd rest on my brief.
Judge Callahan, anything? Judge Hensel, anything? All right, thank you, Attorney DiMartino. And you will have 5 minutes for your rebuttal time, Attorney Kelly.
Thank you, Your Honor. Unless any of the judges have any questions that they would specifically like me to answer for them, I would rest on my brief after that.
Well, what impact do you think the change in the self-defense law had, if any, in these cases?
Well, I mean, the burden shifting, I think probably did have at least some impact. I think that's evident by the difference in the jury verdicts. Back in the first one, the issue was whether or not the defense could prove that they acted in self-defense, and we got a hung jury as it relates to murder, and we got a conviction on a felonious. Now, I think that they were both contrary to the weight of the evidence, but in the second instance, they do credit the trial court for giving Ms. Moss the opportunity to utilize the new laws. It was not required that it be, looked back upon in her case, but that then places an affirmative duty or a burden on the state to prove that it wasn't self-defense. And I don't feel that there was really any evidence offered that it wasn't. As the state stated, the evidence was fairly similar in both cases. And part of that evidence was that there was a life-threatening struggle that took place in that room. And the state's own witness in the first trial, Ms. Stoll, I feel was the one who gave the most credible information regarding that. She really wasn't connected to anything, and her testimony was something to the effect of that there was a fight in that room that sounded like it was going to come through the wall, that it was so bad, a physical altercation. Ms. Stoll couldn't be brought in for the second trial, but once again, the court did allow that testimony to be presented to the jury in full. But I felt like hers was the most persuasive as it relates to that. I mean, because the victim that survived, he did not give consistent information. He straight up denied in both trials that there was any type of a physical confrontation that took place in that room, and the state's evidence contradicted that itself. And if you believe his version of events, then basically what you're hearing is that everybody was getting along just splendidly and Miss Moss pulled out a weapon, but the other people who were in the home, or person that was in the home that did not have any kind of interest in the outcome of the case, disagreed with that and gave contrary testimony. I think that's extremely persuasive, particularly in the second trial, with the burden being on the state that they needed something additional to negate that information.
Thank you. And then the other question I had is concerning the forfeiture based on the failure to object to the prosecutor using the word prior proceeding on cross.
Well, I mean, I think my argument would be that being no objection, usually that is a forfeiture, and or the court can review it under a plain error analysis in almost any instance. However, I would point to the fact that when the argument took place at sidebar with Judge McLaughlin at the trial court, that both of those issues were discussed in detail. And I think that that adequately preserves it for this court to be able to review it under the regular standard.
Okay. Any questions, Judge Callahan or Judge Hensel? Anything further? Attorney Kelly, you've got 1:45 left.
No, Your Honor, I would rest on my brief.
All right. Thank you both for your arguments today and for appearing via Zoom. The court will take the matter under advisement, issue a decision in due course. Of course, each of you will receive a copy of the decision on the day it's released, and the opinions, as you both know, are posted on the Supreme Court of Ohio's website. We hope you're feeling well soon, Attorney Kelly, and thank you for appearing by Zoom, Attorney DiMartino. You both have a great day.
Thanks,
Take
you
care.
too.
Thank you.